And then at the end I'll draw some lessons, and this will take probably about an hour or so, and I'll be happy to take questions afterwards. I've given you the Justices' Conference notes in Brown v. Board of Education. Let me explain what those are, and then I'll talk a little bit about why they're useful, and then I'll just go through them and annotate them, and we can talk some about why Brown was difficult for the justices. When the justices on the Supreme Court get together to decide a case, they have a conference, and the justices are free to keep notes, and those are their personal property. And when they die or retire, they do with them as they please. Some of them destroy them, but some turn them over to public archives. And in fact, 4 of the justices who were sitting on the court at the time of Brown kept conference notes, and those are publicly available. And they actually give us a pretty good record of what the Supreme Court justices were thinking at the time of Brown. To me, it's useful to go through this enterprise with Brown because Brown seems like an easy case. If anything seems unconstitutional today, it's state-mandated segregation, what could be a more obvious violation of the Equal Protection Clause. Also, the case was unanimous, and unanimity connotes easiness, that this was not a very controversial case. I think, in fact, it was very difficult for the justices for reasons that I want to talk about. Indeed, the argument that I'm going to put forward is when they first deliberated on the case, when they first discussed it after the argument in December 1952, there actually weren't 5 votes to strike down school segregation. There were only 4 votes. Okay, so let's go through this. And as I said, I'll draw some lessons at the end. If you've got the notes in front of you, there are 2 different sets of notes here. There are 5 consolidated cases in Brown, as you may be aware. There's a case from South Carolina, a case from Virginia, a case from Delaware, from Kansas, and from the District of Columbia. Now, the first set of notes I've given you just one statement from Chief Justice Vinson from the D.C. case. That's Bowling against Sharp. That technically poses a different legal issue from the issue in the state cases because the District of Columbia is not a state. It's governed by Congress, and the Equal Protection Clause of the 14th Amendment says no state shall deny equal protection. So the technical question in the District of Columbia case is a different question. The technical question there is whether school segregation violates the Due Process Clause of the 5th Amendment, not whether it violates the Equal Protection Clause of the 14th Amendment. Okay, now I'm going to say something about each of the justices just to give you a sense of their personalities and maybe add a little bit of color to this. Chief Justice Vinson is from Kentucky. Kentucky is a border state, meaning that during the Civil War it stayed in the Union even though it was a state with slavery. Vinson is a politician. He had represented the state of Kentucky in Congress for about a dozen years. Then he became Secretary of the Treasury under President Truman. He's presiding over what is, I think it's fair to say, an intensely divided court, both personally divided and jurisprudentially divided. The justices on the Vinson court don't like each other. Justice Black and Justice Jackson have a long-standing feud. Justice Douglas and Justice Frankfurter hate each other. The justices are also divided in terms of their jurisprudence, so there are a lot more separate opinions being filed during the Vinson court than at any time before in the court's history, and this is something that's noted in the newspapers and criticized. Why can't you people get your act together? Why can't you all join the same opinion? Why is it that you're always disagreeing about everything? The only thing that the justices on the Vinson court seem to agree about is that they don't have a great deal of respect for their chief. They actually don't think that highly of Chief Justice Vinson's intellectual and leadership skills. Okay, this is what Vinson says. Congress has not declared there should be no segregation. Hard for the Chief Justice to get away from that construction of the amendments. Schools here have long been segregated. What he's saying is the same Congress that wrote the 14th Amendment is also responsible for running the school system in the District of Columbia. So the same Congress that wrote the amendment went on segregating the schools in the district for the last 80 years. That would seem to give rise to an inference that they didn't think the amendment they were writing mandated an end to segregation, right? If they did, why did they go on segregating the schools for so long? Harlan, in his dissent in Plessy, does not refer to schools. That's significant to the Chief Justice. Harlan was the one dissenter in Plessy against Ferguson, right? That's the 1896 case. that said segregation when mandated by the state on railroads is okay. Harlan was careful in his dissenting opinion not to say anything about schools. So he thought that state-mandated segregation on railroads violated the Constitution, but he certainly did not suggest that state-mandated segregation in schools was unconstitutional. And that's significant to the Chief Justice that the one dissenter in Plessy seemed to think that school segregation was okay. That's significant to the Chief Justice. He can't get away from that construction by those who wrote the amendments and those who followed. Congress has the power to act in the district and in the states. It may act in the district either directly through the Board of Education or by a new statute. Vincent is saying if Congress wants to abolish school segregation, that's perfectly fine, but he's expressing doubts that a court would have the power to do that. Now, notice the justices did not vote after discussing the case. That's unusual. What they usually do is they all speak their piece and then they vote. But they decided not to do that in Brown really for two reasons. One is they wanted to preserve confidentiality, and they were worried that if they took a vote, the news would get out to the newspapers. And the other reason is because they want to preserve fluidity. They want to keep talking about the case during the rest of the term, and they're afraid if they take a vote that people will feel bound to the position that they voted for. So we don't know for sure how Vincent would have voted, but all the justices who were keeping track in their heads about what the vote likely would have been, all of them except for one think that Vincent would have voted to reaffirm Plessy, and that's certainly how I would read the conference notes. Vincent sounds as if school segregation is consistent with the Constitution. Okay, so where does that leave us? Justice Black. Justice Black is the one justice from the Deep South. He comes from the state of Alabama. There are actually 4 justices who come from states with formal segregation. There are 2 from Kentucky, 1 from Texas, but the only one from the core of the Deep South is Justice Black from Alabama. He understands more than any of the other justices what's entailed in striking down school segregation. He understands that the white South is going to resist. He understands that there's going to be violence, that there's going to be school closures, and he's trying to educate his colleagues about this. He wants them to go into this with their eyes open. That's not because he has any problem with striking it down. He actually has a strong vote to strike it down, but he wants them not to think this is going to be a picnic. Now, there are a couple other things about Black that are worth noting. He'd been a member of the Ku Klux Klan in the 1920s. Now, that's pretty bad. It's not quite as bad as it sounds. In the 1920s, about 4 million Americans belonged to the Klan. Black was not a night rider. He did not go around burning crosses on people's lawns, but he would have defended himself in the following way. He would have said, as a litigator in Alabama arguing before Klan-dominated juries, you had to belong to the Klan. And as an aspiring politician, he was going to run for the Senate in 1926, you also had to belong to the Klan. Now, that's not to excuse it, but that's what he would have said in defense. That became an issue upon his confirmation in 1937. Actually, there were rumors that he had been a Klan member, but only after the Senate confirmed him was it verified, and that led to a public uproar, and he actually had to go on national radio talking to tens of millions of Americans, trying to explain to them why the fact that he had been a Klan member a dozen years earlier should not disqualify him from being a member of the court. And he was apparently successful. He was able to keep his seat. Historians, biographers have suggested that Black then spent the rest of his career trying to prove that at heart he was not really a Klan member. One of the first things he did upon becoming a justice was to hire a Catholic secretary and a Jewish law clerk to dispel any allegations of religious prejudice. And from the very beginning of his tenure as a justice, he issued several landmark opinions in race cases in which he demonstrated a strong commitment to racial equality. Now, the last thing I wanted to note about Black is, in a sense, in a very real sense, his vote in Brown is a vote of really extraordinary personal courage. He's going to destroy his son's legal career in Montgomery. His son's going to have to leave the state because of how his father voted in Brown versus Board of Education. Justice Black himself will be regarded as a traitor to his region and his race. He will be persona non grata in the South for at least a decade after the Brown decision. So there is a certain amount of personal courage involved in this. What does Black say? This is under Douglas's conference notes in Brown. There may be violence if the court holds segregation unlawful. States would probably take evasive measures, then there's something that was illegible. I should note this is a librarian's transcription of Justice Douglas's handwritten notes, and some of it was not legible to the librarian. The courts would then be in the firing line for enforcement through injunctions and contempt. This is a repeated theme that comes up during the internal deliberations on Brown. Who's going to bear the burden of really enforcing this? It's not the Supreme Court, it's lower court judges, federal district court judges in the South. They're the ones who are going to have to explain to their neighbors why they're being forced to do something that almost all white Southerners regard as anathema. Can't draw a rational distinction between this case and other cases under the 14th Amendment. I'm just going to skip that. He's compelled to the belief that the reason for segregation is the opinion that colored people are inferior. The amendments have as their basic purpose protection of the Negro against discrimination. Southerners say it, meaning the purpose of segregation, is to prevent the mixture of the races. But Justice Black says, no, the purpose of the law is to discriminate because of color. The amendments were designed to stop that. Okay, he's making an argument about original intent. The purpose of the 14th Amendment was to end discrimination, and the purpose of segregation is to discriminate. He concludes that segregation is per se bad unless the long line of decisions bars that construction of the amendment. Okay, notice, even Justice Black, who seems to think that this is clearly unconstitutional, is bothered by a long line of decisions coming out the other way. Let me just mention briefly what he's talking about. The Supreme Court actually only has a couple of decisions involving the segregation issue, but between 1865 and 1935, there are 44 cases in the lower federal courts and in the highest state courts challenging school segregation, and those decisions are absolutely unanimous. That is, there is not a single one going in the opposite direction. They all reject the constitutional challenge. So there is very strong precedent running in the opposite direction. Notwithstanding that, I'm going to say that Justice Black sounds as if he's prepared to overturn this, but with the qualification that he is troubled by the long line of decisions running in the opposite direction. Okay, Stanley Reed is also from the border state of Kentucky. Of all the justices, he's the one who's most personally supportive of segregation as a policy. He both thinks that it's good policy and that it's permissible under the Constitution. He was in FDR's administration. He was Solicitor General of the United States during the court packing plan struggle in the late 1930s. Like all of Roosevelt's appointments, and this is, I think, important to note, Reed was put on the court really for one reason and one reason only. Roosevelt and Truman, and between them they've appointed all 9 of these justices we're about to talk about. They put people on the court to uphold New Deal economic legislation. Right? They were responding to the earlier controversy in the mid-30s in which the court struck down a dozen New Deal statutes in the period of 18 months. They're trying to get justices who will uphold economic regulation, uphold federal regulatory power. They don't care about the justices' racial views. That was not a salient issue for the court in the mid-1930s. So on the one hand, President Roosevelt will appoint someone like Felix Frankfurter, who's a strong supporter of the NAACP. On the other hand, he'll appoint someone like Jimmy Burns, who is a senator from South Carolina, who is a pretty conventional white supremacist who opposes anti-lynching legislation, anti-poll tax legislation. Right? How can the same president appoint these two people at the different ends of the racial spectrum? The answer is race wasn't Roosevelt's concern. What he cared about was they would uphold the New Deal, and both Jimmy Burns and Felix Frankfurter were liberals on New Deal issues, so they were sound appointments to the court from that perspective. As I said, Reed was the most sympathetic of the justices to segregation. Just one little anecdote about him. The court in 1952 had decided a case interpreting an old public accommodation statute which barred race discrimination in public accommodations, and they were trying to decide whether that law was still in force in the District of Columbia, and they decided that it was, and Justice Reed apparently said something like, after the decision came down, this means that a Negro might sit down next to Mrs. Reed in the Mayflower Hotel restaurant. Right? He was very troubled by the idea that by desegregating public accommodations, he might enforce social equality on his wife if she happened to go out in public and go to a restaurant. Reed thought segregation was a defensible policy. Okay, the conference notes. Reed takes a different view from Black. The state legislatures have informed views on this matter. Minority here, meaning African Americans, has not been assimilated. States are authorized to make up their minds on this question. He's making two different points. He's making a point about federalism, that this issue ought to be resolved at the state level, not by the Supreme Court at the federal level. And he's also making a point about democracy. This ought to be resolved by legislatures who are responsive to the will of the people. It ought not to be decided by unelected federal judges. There's a reasonable body of opinion in the various states for segregation. He's saying this is not necessarily rank discrimination. Reasonable people would think segregation is best both for whites and for blacks. He points to the constant progress in this field and in the advancement of the interests of the Negroes. That's a common theme throughout the conference notes. Several of the justices are struck by how much the world of race relations is already changing as a result of World War II. They don't think they're creating a movement for social reform. They understand that movement is already well underway. States should be left to work out the problem for themselves. Segregation is gradually disappearing, optional in Kansas, Kentucky, and others. He means even without judicial intervention, segregation is gradually disappearing in the border states. He says in Kansas and Kentucky, you have local option. That is, the state does not mandate segregation. It is chosen at the local level, and Kansas cities can decide whether they want to have segregated schools or not. Segregation in the border states will disappear in 15 or 20 years. He means without judicial intervention, it will disappear. What I want to say about that is, that's not a crazy statement. It's not obviously right, but it's not obviously wrong either. If you look at all the things that are going on in border state cities, places like Baltimore, St. Louis, Kansas City, Wilmington, Delaware, there are dramatic changes in race relations. Desegregation of theaters, desegregation of sporting competitions among high school teams, desegregation of teacher associations across race lines. There's a lot of change going on, and Reed is saying that change will also manifest itself in the public schools if you just allow things to evolve gradually. Now notice he doesn't say in Mississippi segregation is going to disappear in 15 or 20 years. What he says about that is, in the Deep South, separate but equal schools must be allowed. Okay, in Kentucky, this will go away of its own accord. In Mississippi, if you try to intervene against this, it's going to produce a firestorm of resistance, and you ought to leave it alone. There's no doubt about Reed. We have lots of internal evidence. Reed, up until the very last minute, was planning to dissent in Brown. He was never persuaded that there was a good constitutional argument against racial segregation. Okay. Justice Frankfurter. Frankfurter, as you may know, was an Austrian immigrant. He was a Jew. He came to the United States at the very end of the 19th century. He didn't speak any English when he came. He quickly became proficient at it. He graduated at the top of his class at Harvard Law School. Then he went back and became a law professor at Harvard, where he served for a quarter of a century before Franklin Roosevelt put him on the court in 1939. Felix Frankfurter arguably knew more about the Supreme Court and its history than anyone who was ever appointed to serve. Unfortunately, he seemed obliged to tell everybody how much he knew, which made him a very irritating person to have as a colleague. He tended to lecture his colleagues at conference. One critic said Frankfurter tended to speak in 50-minute blocks at conference because that was the amount of time allocated to classes at the Harvard Law School. He was apparently very annoying to listen to. He would always be invoking his heroes, his his role models, Brandeis and Holmes. He would always be saying, Holmes once said to me this, and as I once said to Justice Brandeis that, and it was insufferable. His colleagues really couldn't stand him. And his colleagues are very substantial people. I mean, Justice Douglas was offered the vice presidency in 1948. He turned it down probably because he thought Harry Truman had no chance of winning, but he was offered the vice presidential seat on the ticket. Justice Jackson was somebody who was often mentioned as presidential material. These are very substantial figures, and Frankfurter at conference treats them as his students. Douglas especially hated Frankfurter. He was always trying to get under his skin, which apparently was not that difficult to do. Vincent, according to the story, once had to be restrained physically from punching Vincent at conference, which was a good thing because Vincent was a former athlete and Felix Frankfurter was this puny little law professor, and Vincent would have beaten him to a pulp, so it's good somebody stopped him. Frankfurter. These are equity suits. They involve imagination in shaping decrees. He would ask counsel on re-argument to address themselves to problems of enforcement. Notice he's already thinking about the remedy. That would seem to imply that he's also thinking about striking this down. Right? You don't get to the remedial issue unless you're willing to strike down segregation. Also note the point about re-argument. The case will be set for re-argument. That is, the court won't decide it during this 1952 term. They will re-argue it the following term. That's why it's not decided until May of 1954. That's Frankfurter's doing. He's the one responsible for delaying the decision, apparently because he thinks if you delay long enough, maybe you can assemble some sort of unanimity, some sort of consensus. Few things more dangerous than the unfamiliar. How does Black know the purpose of the 14th Amendment? Black and Frankfurter have a long-standing feud about what the people who wrote the 14th Amendment were trying to accomplish, and Frankfurter is referring to that here. Frankfurter, says he's read all of its history, and he can't say it meant to abolish segregation. On Kansas alone, skip that. He wants to know why what has gone before is wrong. That, I think, is also a point about precedent. For a long time, everybody has assumed racial segregation was constitutional. He wants to know why what has gone before. He can't say it's unconstitutional to treat a Negro differently than a white, but he would put all the cases down for re-argument. Sounds to me like he's ambivalent. He wants the case re-argued. He's not sure there's a legal argument against this, but he's thinking about the remedy, which suggests that at least he's open to the possibility of striking this down. I think Frankfurter clearly has not made up his mind. Robert Jackson. Jackson is a lawyer from upstate New York. He was solicitor. He's the last of the justices not to go to law school. This was a time when you could become a lawyer by apprenticing yourself to a senior lawyer. Jackson, somewhat amazingly, given his proficiency as a lawyer, never went to law school. He was Solicitor General and then Attorney General under FDR. He also, as you may know, left the court for a year to be the lead prosecutor at Nuremberg in 1946, 1947. He left the court to prosecute Nazis at Nuremberg. He's an incredibly impressive individual. He's also a terrific stylist. He's arguably the best writer on the Supreme Court since Oliver Wendell Holmes. He and Justice Black, as I mentioned, hate each other. Just to share with you one anecdote, part of the reason for this is when Jackson was off prosecuting Nazis at Nuremberg, Chief Justice Stone dropped dead, and the question was who was going to replace him. Jackson had thought that he would be the next Chief Justice. It may be that FDR had suggested that to him. It may be simply that Jackson thought of himself as obvious Chief Justice material. But in any event, he apparently expected that Truman would make him Chief Justice, and Truman didn't. And Jackson was led to believe that the reason was because Hugo Black had gone to the White House and said, if you make Robert Jackson Chief Justice, I and some other justices will quit. Now, it's not at all clear that that really happened. It's possible that Felix Frankfurter put that thought into Jackson's mind, sowing a little dissension on the court. But in any event, Jackson believed that's what happened, and so he wrote this telegram, a 7-page telegram, in which he basically tried to get back at Black, and he aired some of the court's dirty laundry, and then he publicized the telegram. This was incredibly embarrassing. Here was Robert Jackson saying that Justice Black should have recused himself in a case being argued by his former law partner, and Black was unethical for not doing it. And a lot of people thought that this was just incredibly petty and juvenile, and that both of them should resign, which they didn't do. I'm not sure they ever spoke to each other after that, though. Justice Jackson. Nothing in the text that says this is unconstitutional, nothing in the opinions of the courts that says it's unconstitutional, nothing in the history of the 14th Amendment. On the basis of precedent, he would have to say segregation is okay. Now, what you need to know about that is he's just identified the three leading sources of constitutional law: the text, the original understanding, and the precedent. And he said none of them would justify striking this down. Refers to segregation in New York in the 1860s and in 1890. The reason why he's referring to the 1860s is because that's when the 14th Amendment was written. New York segregated its public schools at the same time that New York ratified the 14th Amendment, thereby giving rise to an inference that when New York ratified the 14th Amendment, it didn't think it was barring school segregation. New York actually went on segregating its schools, at least in some parts of the state, all the way up to 1900, when Governor Theodore Roosevelt signed a law banning school segregation, not until 1900. Says it will be bad for the Negroes to be put into white schools. He won't say it's unconstitutional to practice segregation, but segregation is nearing an end. Not entirely clear what he means by that. Does he mean that it's nearing an end whether courts intervene or not? Or does he mean that courts are going to strike this down sooner or later? We should perhaps give them time to get rid of it, and he would go along on that basis. Again, that's ambiguous. It's not clear whether he means we should strike it down today, but give them a fair amount of time to comply with our decree, or whether he means something very different, which is we should say to them, separate schools today are not equal. Everybody knows that the South doesn't spend as much money on its black schools. We're going to give you some time to equalize, and if you don't do it, then we're going to strike it down. It's a little ambiguous which of those he means. I would put Jackson in the undecided category. He does talk about he would go along on that basis. That sounds as if he's willing to strike it down. But he also told you he couldn't think of a good legal argument to strike it down because he thinks the text and the original understanding and precedent, in fact, do not condemn segregation. William Douglas. Douglas is the one true Westerner on the court. He was born in Minnesota. He grew up in the state of Washington. He, like Justice Jackson, comes from a part of the country where there are very few African Americans. And indeed, Jackson candidly stated he never really thought about race issues until he moved to Washington, D.C. to join the Roosevelt administration in the mid to late 1930s. Same thing's true for Douglas. Grew up in Washington, came to law school at Columbia, then became a law professor at Columbia and Yale. Then he joined the Securities and Exchange Commission in 1936. Not a government position where you would often think about race issues. There's probably no reason to think Douglas ever thought about race issues until the 1940s. He is, however, a paradigmatic New Deal liberal. Those people in the 1930s tend to emphasize class issues, but by World War II, race has become a more dominant issue in their consciousness. And Douglas is a true liberal, and as most true liberals do in the 1940s, they become committed to racial equality, even though 10 years earlier they mostly focused on class issues rather than race issues. The other thing about Douglas to note is he's a real iconoclast on the court. He takes positions that I think can only be described as aberrational among the justices. He wrote a famous opinion about around 1970 saying that trees ought to have standing to bring environmental lawsuits. That was not a position that was widely shared at the time. He was also the only justice who was prepared to join the Vietnam War. The rest of them wanted nothing to do with this. Douglas was prepared to say Congress never declared war and therefore the war is unconstitutional. He's not well liked by his colleagues. His law clerks live in constant fear of his temper. There's a story in the new biography by Bruce Murphy that I love about how Douglas is voted Father of the Year in 1950, and his kids get a real kick out of this because they think he's a terrible father, but somebody didn't consult them in deciding that he's Father of the Year. He's truly an awful person, but he has political views that his biographer admires, and a lot of people admire. I mean, to my parents' generation, Justice Douglas was one of the heroic figures of the mid-20th century. He stood up against McCarthyism. He was a strong vote for racial equality. He was also not popular with his colleagues because Douglas was a brilliant man, and he thought that the job was just too easy. And he was always saying things like, we don't work hard enough, we need to take more cases, we need to have fewer law clerks. And his colleagues thought they worked plenty hard and didn't really want Justice Douglas going around saying we should have our pay cut because we don't work that hard. That doesn't make you popular with your colleagues. That's a general lesson about life, I think, in general. Your colleagues probably don't want to hear that. What did Douglas say? Segregation is an easy problem. Now, notice that actually can be read in one of two ways. To his moral credit, he sees this as an easy issue. I think he should get credit for that. However, I think that's probably an optimistic way to interpret this. What he's really trying to do is get under Frankfurter's skin, because Frankfurter's just told you what a hard case this is, and therefore Douglas is inclined to say, Felix, why do you think this is hard? This is actually very easy. No classification on the basis of race can be made. 14th Amendment prohibits racial classifications. So does the Due Process Clause of the 5th. A Negro can't be put by the state in one room because he's black and another put in the other room because he's white. The answer is simple, though the application of it may present great difficulties. Nobody ever doubted how William Douglas was going to vote on the question of school segregation. Okay, that just leaves us a couple more. The Truman appointees. Truman appointed the chief, Vincent, but he also appointed Burton, Clark, and Minton. Burton is the only Republican on the court, but he was also appointed by a Democratic president. He is a liberal Republican who is a supporter of the New Deal, Fair Deal policies of the Roosevelt and Truman administration. He was mayor of Cleveland, that is in a part of the state of Ohio known as the Western Reserve, which has a strong tradition of racial equality dating back well before the Civil War. Cleveland's public schools were actually integrated in the 1830s, which is not something you would say about most northern schools in the antebellum period. Burton is one of Truman's cronies from the Senate. He and Truman got to know each other when they were both senators in the early 1940s, and that is one of the reasons why he was appointed to the Supreme Court. What does Burton say? Sipple will cross the threshold of these cases. He's actually referring more than Sipple. He's referring to a case called Sweat versus Painter, which is the 1950 Texas law school case. And what the court said there was the state of Texas had tried to create a separate black law school virtually overnight in order to avoid integrating the University of Texas white law school. And the court had struck that down. And the rationale for striking it down was there are intangible features of a law school education that can't be duplicated through an overnight law school. And he was talking about, the court was talking about things like the quality of the institution, the prestige that it's developed, the quality of the alumni body. Those kinds of intangibles make a separate institution necessarily unequal. Those cases cross the threshold of these cases. Education is more than buildings and faculties. It's a habit of mind. With the 14th Amendment, states do not have the choice. Segregation violates equal protection. The total effect is that separate education is not sufficient for today's problems. Just skip down to the bottom. Fifth Amendment bars segregation. He would give plenty of time in the decree. Okay, no doubt how Burton is voting. He's a clear vote to overrule Plessy versus Ferguson. Okay, Clark, just briefly, is from Texas. Texas is part of the peripheral South. There are parts of Texas, West Texas, where there are almost no African Americans, and school desegregation is just not going to be a problem. There are also counties in East Texas, which resemble Mississippi, that are majority black, and where whites are dead set committed to preserving white supremacy. So Texas kind of looks in both directions. Clark was Attorney General under Harry Truman. He's a member of Truman's cabinet. The other thing I'll note about Clark is he's actually fairly conservative as among these justices. He will be a frequent dissenter from the Warren Court, criminal procedure decisions. He's also probably the fiercest of the cold warriors on the court. On national security issues, he is a solid vote in favor of the government against the rights of political dissidents. Clark, result must be the same in all these cases. I think there he's evidencing a kind of conventional Southern white view about regional prejudice. He's saying Northerners are always ganging up on the white South, saying how bad we are, but in fact the North has its race problems too, they just don't admit it. I think he's saying there has to be the same rule for the whole country. This is very similar to what Justice Powell says in some of the 1970s cases involving Northern desegregation. Justice Powell, who's from Richmond, I think shared this view that there's a lot of hypocrisy among white Northerners. They're always criticizing the white South, but they have segregated schools in the North too. And Justice Powell wrote a famous opinion in the Keyes case in 1973 from Denver, in which he said we ought to have the same rule in the North that we have in the South. I think that's what Clark's alluding to. Refers to Texas, where the problem is as acute as anywhere. Texas also has the Mexican problem. Mexican boy of 12 is in a class with a Negro girl of 12. Some Negro girls get in trouble. I think he means pregnant. If we can delay action, it will help. Opinion should give lower courts the right to withhold relief in light of troubles. Notice he's talking about relief. That sounds like he's striking it down. He would go along on that. Otherwise, he would say we had led the states on to think segregation is okay. Again, the point about precedent, the Supreme Court has created a reliance interest in segregation, and we should let them work it out. Okay, Clark clearly says things that point in both directions. Sounds like he could go along with a decision either way, depending on what he decides he wants to do. Sherman Minchin is the last of the Truman appointees. He was a senator from Indiana, again another of Truman's cronies in the Senate. He is not a liberal on most issues. On free speech issues, on criminal procedure issues, he's actually one of the most conservative justices, but it turns out on race, he is a fourth solid vote to strike this down. Body of law has laid down separate but equal doctrine. He's talking about the precedents. That, however, has been whittled away in these cases. He's referring to cases like that 1950 Texas Law School decision that I referred to earlier. Classification on the basis of race does not add up. It's invidious and can't be maintained. I don't think there's any doubt how Minchin is going to vote on this issue. Okay, take a look at the next page. Justice Douglas wrote a memo to the files. Mine's out of order, I don't know about yours. We want page 3, which is the first page of the Douglas memo to the files. Justice Douglas dictated this memo on the day Brown was decided, May 17, 1954. Now notice the conference notes are more reliable than the memo to the files. The conference notes are Justice Douglas just writing down what happens at conference, and he turns out to be a pretty good note taker. The memo to the files are Justice Douglas's effort to leave a trail for historians. He wants history to be told from his perspective. So you have to take this with a grain of salt, especially when you keep in mind the fact that he hates Frankfurter, so he might want Frankfurter not to be so well regarded by history. Skip the first paragraph and just look at the second. In the original conference, that's what we just read, there were only 4 who voted that segregation in the public schools was unconstitutional. Those 4 were Black, Burton, Douglas, myself, and Minton. Vinson was of the opinion that Plessy was right and segregation was constitutional. Reed followed the view of Vinson, and Clark was inclined that way, okay? He puts Clark in the reaffirm category, and he was there and I wasn't. I read the conference notes more to suggest that Clark was undecided, but he's saying Clark actually would have been a vote to reaffirm. In the 1952 conference, Frankfurter and Jackson viewed the problem with great alarm and thought that the court should not decide the question if it was possible to avoid it. Both of them expressed the view that segregation in the public schools was probably constitutional. Frankfurter drew a distinction. We didn't see this. This was in a different set of conference notes. Frankfurter drew a distinction between segregation in the public schools of the District of Columbia and segregation in the public schools in the states. He thought that segregation in the public schools of the District of Columbia violated due process. That's true. Frankfurter said he would vote today to strike down segregation in the district. His problem was with striking it down in the states. And if you ask me why he thought that it was obviously unconstitutional in the district, the legal argument in the district was actually weaker. Because in the district there was no equal protection clause. It was the moral argument in the district that he was persuaded by. To Felix Frankfurter, it was unacceptable to have racial segregation in what he thought of as the capital of the free world. Right? You can't have racial segregation in the nation's capital. He thought segregation in the public schools of the District of Columbia violated due process, but he thought that history was against the claim of unconstitutionality as applied to the public schools of the states. So as a result of the informal vote at the 52 conference, it seemed that if the cases were to be then decided, the vote would be 5-4 in favor of the constitutionality of segregation in the public schools in the states, with Frankfurter indicating he would join the four of us when it came to the District of Columbia case. Okay, I'll stop there. That's amazing, right? I mean, if there had been a vote in December 1952, there is at least a plausible case, and maybe a strong case, that they would have voted 5-4 not to strike down school segregation. Okay, at a minimum, they might have come out with a bunch of divided opinions, right? Some of the justices, Frankfurter, for example, in his own head count, also thought they would be 5-4, but he thought it would be 5-4 the other way, with Felix Frankfurter joining these four. Right? So there is some self-interest in this. Douglas puts Frankfurter on the other side. Frankfurter puts himself on the side of striking this down. How do you get from there to unanimity? Right? At the minimum, we have a divided court, and arguably we don't even have 5 votes to strike it down. How do you get from there to unanimity? Well, the first thing to note is Chief Justice Vinson drops dead suddenly in September of 1953. He's a fairly young man. He's about 62, but he had a heart attack and he died. Felix Frankfurter was, some of you may have heard this before, Felix Frankfurter was recorded as noting that this was the first evidence he had of God's existence. The fact that the Chief Justice dropped dead. Right? Frankfurter was a great guy, expressing great sympathy for his colleague's passing. That means there's going to be a new Chief Justice. That Chief Justice turns out to be Earl Warren. Earl Warren was appointed by Eisenhower because Eisenhower believed he owed him a political debt from the 1952 Republican Convention, when he believed that Warren swayed the California delegation to vote with Eisenhower on a key issue, and it was a closely contested convention. Eisenhower was, in a sense, the underdog. Most people thought Robert Taft would be nominated, and in fact, it was Eisenhower, and he believed he owed his nomination partly to Warren. Warren is now the Chief Justice. Brown has re-argued, and here's what Warren says at the beginning of the 1953 conference. I did not give you this. This is in a different set of conference notes. Quote, "Separate but equal rests on the basic premise that the Negro race is inferior. That's the only way to sustain Plessy. Chief Justice does not see how segregation can be justified in this day and age." Okay, now it is clear to anyone who's keeping track, anyone who's counting heads, and they all are, that there are 5 votes to strike down segregation. Now, Supreme Court majorities require 5 votes. So it's now clear what the result's going to be. My argument was a year earlier, it was not clear what the result was going to be. Now the only question is, what's the vote going to be? Right? It's going to be a majority to strike this down. What's the vote going to be? There are 2 factors pushing strongly in the direction of unanimity. One is, everybody on the court understands that the white South is going to fiercely resist this decision. They don't want to give critics anything to latch on to. So there's a lot of pressure on those who don't agree with the result not to write a dissent. After all, you could write a pretty good dissent just by taking the points that were made at conference. Right? Justice Jackson said, there's no textual argument against this, there's no originalist argument, there's no argument based on precedent. You could write a pretty powerful dissent. So there's a lot of pressure on the justices who might dissent not to do so for the good of the court. Right? The institution needs this decision to be enforceable. So Justice Reed is especially subjected to a lobbying campaign that lasts over a several-month period and at the last minute, Reed, for the good of the court, decides to go along with the decision. He was never persuaded that this case was rightly decided. He went along for what he perceived to be the good of the court. Now, there's another reason, I think, that might explain more why these justices go along. For Frankfurter and Jackson, Brown presents a conflict between their personal views and their legal or jurisprudential views. Nobody who knew these men would have doubted that Frankfurter and Jackson thought racial segregation was anathema. Jackson wrote a telling letter in 1950 to a law professor friend in which he said, "Nobody who spent time prosecuting Nazis in Nuremberg has any doubt that racial segregation is morally evil." Justice Black at one conference referred to racial segregation as Hitler's creed. That's how Jackson and Frankfurter thought of it. They thought it was morally wrong. They also thought that it's a judge's job not to write their moral philosophy into the Constitution. They're supposed to interpret the Constitution according to conventional strategies like text, original intent, precedent, custom, and tradition. So the case for them presents a conflict between their moral views and their legal views. And what I would suggest to you is, in 1952, when they still controlled the outcome, they would have been more willing to stand up for their legal views, even though it put them in a morally uncomfortable position. In 1953, they're now irrelevant to the outcome. The only question is, are they going to dissent or not? They can't affect the outcome anymore, and I think in that situation, they're no longer willing to make a stand for their legal principles because it puts them in such an unpalatable political situation. Right? They don't want to be dissenting from a decision striking down segregation because they think that segregation is a moral evil as well. Okay, so that's my argument about how you get unanimity. I said I was going to draw some lessons. I've been talking a long time, but let me draw at least a couple lessons quickly. First point, the justices did not, and I mentioned this with Reed, they didn't see themselves as creating a social reform movement. They understood that deep-seated forces were already pushing the country toward racial equality, and they were simply latching on to that. Right? They saw themselves as pushing in the same direction that the country was already moving in. And let me just note a couple of these statements. Frankfurter noted in a memo that he wrote while Brown was pending, quote, he noted the great changes in the relations between white and colored people since the First World War, and he also remarked, quote, the pace of progress has surprised even those most eager in its promotion. Right? Frankfurter understands how much things are already changing. Jackson went even further. He observed, quote, Negro progress under segregation has been spectacular and tested by the pace of history. His rise is one of the swiftest and most dramatic advances in the annals of man. Separate point. Minton and Burton are, in a way, the most difficult votes to explain. These are justices who take seriously the idea of judicial deference to legislatures. On most civil liberties issues, issues of the First Amendment rights of political radicals, rights against search and seizure, rights to appointed counsel, rights against coerced confessions, these are the two most conservative judges on the court. Yet on race, it turns out, they were two of the most liberal justices. Is there any easy way to reconcile their positions? I think there is a pretty good argument, although this is speculative. Burton and Minton are strong cold warriors. When the issue is the First Amendment rights of political radicals, they almost always side with the government. Right? When the issue is throwing communists in jail for violating the Smith Act, or legislatures investigating alleged communists, they always side with the government. Well, what you need to know about Brown, and this will be news to many of you, but maybe not to all of you, Brown presented a kind of national security imperative for the national government. The national government wrote a brief, the Justice Department wrote a brief in Brown, and it may surprise you to hear that their main argument was to quote the State Department to the effect that the United States, as a matter of national security, needs to fix its race relations because this is killing us in our competition with the Soviet Union for the allegiance of the Third World. Right? This is the height of the Cold War. Right? 1954 is the peak of McCarthyism. And the national government is trying to convince African and Asian nations that they ought to side with democratic capitalism rather than Soviet communism. And the problem for them is that the Soviets keep reminding the rest of the world about white supremacy in the South. So every time there's a big racial incident, Emmett Till gets lynched in 1955. There's a race riot in Cicero, Illinois, when a black family tries to move in a white neighborhood in 1951. Every time one of those incidents takes place, the Soviets beam it around the world, and it becomes very difficult for the U.S. delegation at the UN to explain to African and Asian nations why democratic capitalism is such a good thing. The Justice Department emphasizes that first and foremost in their brief, and I think that was music to the ears of Burton and Minton. Here is the national government saying to them as cold warriors, you need to strike down school segregation as a national security imperative. And they're the justices who are most likely to be influenced by that. Last point I wanted to make about the Supreme Court and its legitimacy and where it comes from. Supreme Court justices often say things like, our legitimacy depends on our ability to convince the public that our decisions are grounded in legal principle, that we're not making things up, that in fact we follow neutral principles of law, and we're not simply writing our political preferences into the Constitution. Well, I want to suggest that that may not be right. Brown versus Board of Education was intensely controversial when it was decided. Half the country in opinion polls opposed the decision. Leading legal academics and judges, people like Learned Hand, Herbert Wechsler, the great law professor at Columbia, they wrote bitter denunciations of the court's decision in the late 1950s. And notice from the conference notes, justices like Frankfurter and Jackson were not persuaded themselves that there was a good legal argument to accommodate the result that they wanted to reach. Jackson was very candid about this. In another set of conference notes, he said, I will go along with this as a political decision. I will not pretend that it is a defensible legal result. All right, so the justices themselves were not completely convinced that they had a good legal argument. Yet 50 years later, Brown has achieved iconic status. Everybody agrees it's rightly decided. You could not possibly become a judge on a federal court if you went before the Senate Judiciary Committee and criticized Brown. As a constitutional theorist, you have no chance of being taken seriously unless your constitutional theory, your theory of interpretation, can defend the Brown decision. What that suggests to me is that in the long term, the legitimacy of the court doesn't depend on the quality of its legal reasoning. It really depends, in a sense, on reaching the morally correct outcomes, at least as judged by long-term public opinion. Right? Brown is iconic not because the legal reasoning was persuasive. It's iconic because we all see it as a morally just result. In 1954, the country was divided about that. 50 years later, we're no longer divided, and that's why Brown seems right. Brown is a tremendous source of the court's legitimacy, but again, I emphasize that doesn't come from the quality of the legal reasoning. It comes from the attractiveness as a moral matter of the outcome. Okay? Happy to take questions.
I wonder about these polls. Were they with women and men, or just men, or who were in the polls?
The Gallup polls are taken the same way as Gallup polls today. I'm not aware of them doing gender breakdown on these issues. They did on other issues. If you go back and look at volumes of Gallup polls, and this is something that you would assume a not very normal law professor would do, it's actually a lot of fun. I recommend this to you. They have wonderful questions about, what size skirt women should be allowed to wear in public, and just really bizarre things. And those they do actually test on gender grounds. I'm not aware of them asking the question, do you think public schools ought to be segregated or not on gender grounds? They ask them on regional grounds, so you get a very different answer among Northerners and Southerners, and they break them down also on educational grounds, so you find what I think would be predictable, that very well-educated people are more supportive of Brown than high school dropouts would be, and you find strong correlations on polls today on educational background as well, on issues like gay rights and flag burning. So you found that on racial segregation. But I've never seen anything suggesting that, for example, in the South, that white women and white men felt differently about racial segregation.
How would the Gallup polls administered on the telephone or in writing?
I'm not sure about that. I mean, in the 1930s, there had been that famous Literary Digest poll which demonstrated that if you interview people with telephones, you're likely to be interviewing higher class people, and they therefore came to the odd outcome that Alf Landon was going to beat FDR in 1936. They had figured, I mean, that had been ridiculed, and people had figured out that problem. So I think Gallup knows what it's doing in 1954. I think they just don't expect a gender breakdown on racial segregation issues. Interestingly, since you raise it, you do find that breakdown today on issues like same-sex marriage. On gay rights issues generally, there's actually more support for the progressive position among women than there is among men.
But in that time, if you called someone on the telephone, would a man answer or a woman? If they did it by telephone, I would think a man would be answering.
Depends what time of day they call, right? I mean, if they call during the day.
Therefore, this whole thing would be skewed about who would be in favor.
If you assume that there is any reason to think there's a gender breakdown on this race issue, and I've just seen nothing suggesting that there was in 1954, what are you intuiting? That, in fact, women would have been more supportive of Brown? Yeah. I wonder about that. I mean, I think on the question of how dead set in opposition you are, right? They did ask the question, how far are you prepared to go in opposition? And opinion polls show that Southern whites, 15 to 25%, would be prepared to use violence to oppose desegregation. I wouldn't be at all surprised to see a gender breakdown on that. And if the question was, how supportive of your school closures, I think there you'd probably find a gender breakdown as well. And I know for a fact that women were often responsible for, they were often the motivating forces in these parent organizations to save our schools, to keep them open. But on the question of, do you favor racial segregation, I guess I've never seen any reason to think there was a gender breakdown, but I just don't know for sure. Yeah?
I was just wondering if any of the other conference notes showed Burton and Minton mentioning the national security issue, because I don't see that. So that's more, I mean, that's
can't find any explicit references in any of the justices' papers. It's in the briefs. It's in newspaper reaction to Brown. So if you look, Brown is an incredibly salient event. So the New York Times has first front page headlines, and the New York Times editorial will talk about how the United States can now raise its head in the world. There's actually correspondence to the justices. Justice Burton gets a letter saying something about how you've struck a blow for democracy in the world. But the only reference I've ever found directly to the Cold War imperative is Justice Reed saying to a law clerk, as recounted by the law clerk, I've been hearing a lot about that Cold War imperative, and it's been making me think, but I don't think it ought to be relevant. That's the only direct reference. But, it is speculative, but I just don't regard that as dispositive. I mean, the justices will usually not talk about things that don't seem relevant, but that are. For example, the court in 1944 struck down the white primary, saying it's unconstitutional for the Democratic Party to exclude blacks from participating. There is no reference in the opinion or in the conference notes to World War II, which is going on simultaneously, and the fact that African American soldiers are risking and sometimes giving up their lives fighting for democracy, but they can't vote in the only elections that matter in the South. I just think it's absolutely clear that that weighed on the justices, but they didn't say anything about it, right? Another case I could show you, in 1968, they decided a case on the fair housing issue, interpreting an old Jones versus Alfred Mayer. I don't know if the case rings a bell. They're interpreting an old Reconstruction-era statute in a very creative way. Well, they had conference on the case like a day or two after Martin Luther King was assassinated and Washington, D.C. was burning down around them. And I just have no doubt that that influenced the way they came, but they don't say that in the opinion, right? Because it doesn't seem that relevant to legal analysis. Yes, sir.
I wanted to ask a question about Bowling v. Sharp. Because as you said, the constitutional basis for that decision is even more problematic than the basis for Brown. And in particular, the thing that intrigues me is, why Black went along with Bowling v. Sharp. Basically, it's a substantive due process decision. And just a few years after Brown, of course, in Griswold versus Connecticut, Black is excoriating his colleagues for reviving substantive due process to protect the right to privacy. Is there no evidence that Bowling v. Sharp bothered Black at all, or some of the other justices, on the grounds that it was reviving substantive due process?
Let me just lay a little bit of background. Substantive due process is a doctrine that had been prevalent in the early part of the century, and it basically allowed the court to strike down economic regulations by reading a right to contract or a right to economic liberty into the Constitution. It was very controversial, and among these justices appointed by Roosevelt and Truman, they all repudiated substantive due process. They thought it was an invented doctrine. They believed judges should defer to legislatures on issues of economic regulation. And Justice Black often referred to himself as a textualist. He didn't believe in reading things into the Constitution, and yet there is no equal protection clause for confining Congress's discretion. There's only a due process clause. The interesting point about this, the only thing I find in the conference notes is Justice Frankfurter thinking that Bowling is actually an easier case. And I think the only explanation for that is the kind of moral argument. Can you imagine the Supreme Court saying school segregation is unconstitutional in every state in the Union, but in the nation's capital it's okay because there is no constitutional provision plainly barring it? I think this was like the national government in the 1850s saying we're going to bar the slave trade in the District of Columbia. Right? We're not going to go into the states and eliminate slavery, but you cannot have the slave trade going on within sight of the capital of this nation committed to equality. And I think Frankfurter thought the same thing during the Cold War, when the United States is supposed to be a bastion of democracy in the world. You can't have segregation in the nation's capital. It's not a legal argument. It is a moral argument, but I think the other thing about the District of Columbia is it is a much easier case in not in a legal sense, but in a practical, consequential sense, because in the District of Columbia, they're actually going to be able to desegregate the schools without a lot of fuss. Eisenhower had run in 1952 on a platform of desegregating those areas within federal control. So Eisenhower was committed to desegregating military schools, schools on military bases, and schools in the District of Columbia. So whether the court decided this case or not, the schools in the district were going to be desegregated by Eisenhower. And you might actually see that as an argument for deferring, right? Saying we don't need to do this, the political branches are going to do it. And there is actually some reference in the conference notes that it would be a good thing to allow this to happen through the political process, but at the end of the day, they were not willing to strike this down in the states and leave it alone in the district. No, I see no evidence that Justice Black ever had any legal hesitation about this. I think he's inconsistent on that. Any of the students? Yes, sir. Go ahead.
I am curious about a couple things. In terms of the Bowling versus Sharp argument, I am curious as to how you think about the notion of, based on your headings, the question of overruling Plessy is important in Brown, but isn't the same question in Bowling versus Sharp. Because if Plessy is based on 14th Amendment theories and Bowling versus Sharp is based on 5th, then at least you don't have to overcome the notion of overruling a case that's already been decided by the court. And that, at least in theory, might have had something, may have had a little bit of play with respect to Frankfurter and Jackson. But the question I actually want to ask is a slightly different one.
But there is precedent in the district.
Sure.
I mean,
But
The Supreme Court hasn't decided the case in the District of Columbia, but there are lots of lower court decisions upholding school segregation, and there's the fact that Congress, which wrote the 14th Amendment, has gone on segregating the District of Columbia schools. So I think they're still going to regard precedent as against them even in the district.
And that's fair, although, okay, that's fair. The other question, though, deals with how or why one would look at how courts have interpreted the 14th Amendment through time, given that the 14th Amendment arguably was stripped of a lot of its oomph in the Reconstruction time period. So that the notion of looking at precedent doesn't arguably be viewed as being somewhat irrelevant, given that that precedent was based on a vision of the 14th Amendment that wasn't true to the 14th Amendment's original purpose.
Yeah, that's an interesting question. I mean, the justices are very much reared on the sort of conventional Southern interpretation of Reconstruction. Justices Frankfurter and Jackson, when they refer to Reconstruction in private documents, refer to it the way that Southern historians in the Dunning School refer to it. This is a time when crazed, vindictive, partisan Republicans tried to impose an unnatural sort of regime in the South. And I take it what you're suggesting is a lot of the courts interpreting the 14th Amendment, like the Plessy Court, gutted it of its original understanding. It's true that there was an understanding of Reconstruction that developed that I don't think was a very accurate one, but I also don't think it's very accurate to say that the purpose of the 14th Amendment was to abolish all racial distinctions and to end segregation. The Republicans who wrote the 14th Amendment were actually, many of them, a fairly racist bunch. Not all of them, not Charles Sumner, not Thaddeus Stevens, but a lot of Republicans, for example, were not willing to bar limits on black suffrage, right? There's one reason why the 15th Amendment is necessary is because Republicans were not willing to write into the 14th Amendment a ban on excluding blacks from voting. The only time the issue came up during the debates was when Democrats would say things like, the 14th Amendment is going to desegregate schools, how can you support that amendment? And Republicans would always say in response, what are you, crazy? This doesn't have that effect. This is about civil rights. This is about equality of contract rights, equality of property rights. It's not about political rights like the right to vote. It's not about social rights like the right to interracial marriage or the right to integrated school. So, I think most historians' views today, not just over time being influenced by the Southern perspective, most historians' views today is that there's really not a very good originalist argument against school segregation. You can only get that by reading the 14th Amendment at a very high level of generality. Right? That's not to say Brown's wrong, it's just to say if you're an originalist, it's very hard to defend Brown. And I think that's been a political nightmare for a lot of conservative constitutional scholars like Bork or Scalia or Thomas, because nobody wants to be in the camp of saying Brown's wrongly decided. But I think if you're really an originalist, I think you're stuck with Brown being wrongly decided. Right? Maybe that's a pretty good argument against originalism.
One more question.
Could I just respond to what you just said?
Sure.
Okay. Your argument assumes what many scholars now call an unsophisticated version of originalism. Bork and Scalia and so forth would take the position that you don't look at the Equal Protection Clause in terms of how it was applied, i.e. in terms of whether or not it would have struck down segregation in the schools. You do, in fact, look for the general principle. Right. And plenty of sophisticated originalists would say that the general principle in the Equal Protection Clause is clear and is perfectly capable of being used to strike down segregated education.
Right. I'm glad you raised that. That's exactly what Scalia would actually say. You don't have to focus on original intent. You just look at the text, and the text is clear. But an originalist like Bork would say, or Mike McConnell might say something like what you did. The problem with that is that they're looking at a higher level of generality, but they are arbitrarily picking an intermediate level of generality rather than just generalizing to the next level. So, for example, they don't want the position that segregated schools are okay, so they read the original understanding at a higher level of generality, and they say the framers were committed to racial equality. But you could read it at an even higher level of generality and say the framers were simply committed to equality. Given their understanding of the world, black people were oppressed, but women and gays were not. But if you just read it at a higher level of generality and say they were committed to equality, and if they understood that the world would change so that people would see women as oppressed and gays as oppressed, then they also would have been committed to same-sex marriage. Now, originalists don't want to go that far because they don't believe that's the court's job, but they do want to go far enough to Brown. And what I would say in response to what you call the sophisticated view of originalism, and I believe it is more sophisticated, is that it's also arbitrary. They're picking an arbitrary level of generality, and there's no reason once you make that move, you shouldn't make the next move, and they're not prepared to make that. So I think that is a kind of random way of accommodating Brown without moving to the next step.
Can I ask one final question? Sure. If we do a close reading of this 1952 conference and we look at it from the perspective of the plaintiff's lawyers, we tend to have valorized the NAACP lawyers for their canny legal strategy. And you're offering a contingent analysis of Brown. Should we look at NAACP strategy differently? The potential for a negative outcome seems stronger than sometimes the way we, especially historians, talk about the march of legal cases.
Right.
Would you offer some different analysis of their strategy potentially?
Well, you know, it's pretty interesting. I mean, the NAACP forced these to be desegregation cases. In the local communities in Clarendon County, South Carolina, in Prince Edward County, Virginia, these lawsuits were begun as equality demands. The people in the local community were demanding bus transportation. They were demanding improvements in black schools, which were dramatically substandard compared to the white schools. The NAACP in 1950 said, we're not taking any more equalization cases. We think equalization is demanding a better form of segregation, and we're not interested in that. So what they said to these local blacks was, we're willing to take your case, but only if you're willing to go to the next step and demand integration. That was controversial. There were critics. There was a famous woman correspondent in the Pittsburgh Courier, I forget her name, who criticized the NAACP. They said, look, if you ask for equalization, you're sure to win. If you ask for integration, you may lose. And there was some sentiment within the NAACP that this was risky. They weren't sure they were going to win, and they thought if they lost, this might set back the cause for another generation. And as I hope I showed, it wasn't obvious that they were going to win. You know, they took a chance. I think, you know, to some extent, they were not in complete control of the litigation. One thing that especially made them hesitate, Roy Wilkins, the head of the NAACP, later said, the last case we wanted to be litigating was Clarendon County, South Carolina. Right? That is a core, deep South county where blacks are 70% of the population and 90% of the public school population, and whites in Clarendon County will shut down their schools rather than integrate them. Which is in fact what happened in Clarendon County when they finally got a court order to integrate in the late 1960s. The whites left the public school system. So, you know, they don't have complete control over what they're doing. I think what the NAACP would really like is a case from Richmond, a case from Nashville, a case from Little Rock, cases where, you know, you have southern urban communities where you're not likely to get a last-ditch stand against desegregation, but they couldn't control what was going on. I mean, that's one of the lessons, I think, of litigation, is you can't always control the order in which these cases come up.
Before we thank Professor Klarman, I just have a couple announcements. One last question, sure.
I'm curious about, you said that you didn't feel like the justices are creating a social reform movement. And that's even acknowledging the fact that 50% of Americans didn't agree with the decision. And where it's going to be applied in the South, that percentage is probably up to close to 90%.
Of whites, absolutely.
Right. And even recognizing that the NAACP is pushing the issue in terms of what African Americans are thinking, and recognizing that Brown is most likely going to be expanded outside of schools to cover every aspect of Southern life. So I'm curious how you don't see, or why you don't see the justices as taking a bigger step, or at least a substantial step, in addition to, a gathering reform movement that I think we all recognize?
Well, it is a significant step, and in some ways, by taking this significant step, they actually produce a fair amount of retrogression in the South, right? There is a kind of gradual change going on, and you're getting the desegregation of urban police forces, the desegregation of minor league baseball teams. In cities like in the border areas, you're getting desegregation of public accommodations, public swimming pools. Schools are an area where white Southerners are going to be most resistant to change, and by forcing that to the front of the agenda and inspiring African Americans to start demanding school desegregation, you actually produce a massive backlash in the South in the short term. So you get a radicalization of politics, you get the creation of demagogic politicians like George Wallace, you get the comeback of Bull Connor in Birmingham. And then, when you finally get a civil rights direct action protest, where I think people disagree about how much Brown contributed to it, but when you finally get that protest movement, you have such a radicalized Southern politics that it's actually greeted by violence in places like Birmingham and Selma, which leads to televised scenes of law enforcement officers beating up peaceful protesters. But, I don't really see Brown as causing the sit-ins. And, this is a complicated argument that I talk about at some length in my book, but the most direct piece of evidence is the Montgomery bus boycott, I don't think has really much of anything to do with Brown, yet that breaks out at around the same time. And I think that demonstrates that African Americans in the South are beginning to take control and to demand change. They're not going to allow themselves to be pushed around in the same way. And that's the kind of explosion that really takes place in 1960 with the sit-in demonstrations. I think the real question is, what's the linkage between Brown and that, right? Because it's direct action protest that ultimately is going to produce transformative change. And I just don't see Brown as being a very direct contributor to that. I think it plays some indirect roles, but I think it's very complicated. We can talk more about that afterwards if you want. But I explore that in the last 100 pages of the book. And the argument is, I think, controversial, but I'm persuaded by it.
Let me make two announcements before we thank Professor Klarman. Now that he's mentioned his book, it's for sale right here, if anybody wants to buy a copy, from Jim Crow to Civil Rights, The Struggle for Racial Justice, do I have the title right?
The Supreme Court and the Struggle for Racial Equality.
Thank you. And we're having a small reception right around the corner if anybody wants to join us in the lounge right here. Thank you.
Sure.